Okay, I think we can get started. Again, welcome to this week's office hours for ESG and ESGCV. My name is LaQuantia Goodman, and I am today's moderator. If you are just joining us, please go to the chat and introduce yourself with your name and the region you represent. As a reminder, this office hours session is being recorded for public record. Office hours recordings are on the California ESGCV past trainings webpage. A copy of the slide deck and recording will also be emailed to you. Next slide. How to ask a question. All questions must be submitted in the chat box. Please type your organization and question into the chat box. The team will read questions out loud at the end of the presentation and will provide answers, if possible, throughout the presentation. All questions and answers entered in the chat box will be recorded as part of the public record. Alongside our presenters, we also have several HCD staff, including ESG representatives, ESGCV grant administrators, and other consultants who are able to answer questions during the question and answer session. Next slide. Today's office hours session agenda includes the following: ESG resources and ESGCV updates, office hours updates, upcoming trainings, ESG and ESGCV question and answer, and today's spotlight session, ESG and the Violence Against Women Act, VAWA. Next slide. I'll now turn it over to Anthony Zapata. Sorry.
Thank you very much. Good morning, everyone. I hope you're enjoying this wonderful Wednesday. Just a few reminders and updates in terms of contract years. You see the slide. I'm going to start at the bottom. A reminder that the 2021 contracts the expenditure deadline is August 31st of this year, approximately 3 months from now. So now is the time. Start sending in those RFFs so we can get you paid, and you can continue providing your services, and we won't have a mad scramble at the end of the year. If you have any questions on that, of course, you can contact your rep or at the ESG NOFA inbox. The 2022 ESG award announcements were announced last Friday on May 12th. An email went out letting our grantees know who was awarded and what the next steps are. We anticipate the contracts will be finalized in July of this year. And then on to the 2023 ESG annual NOFA release date is going to be by the end of this month. So just sometime in the next 2 weeks. And once that is announced, we will immediately schedule webinars for anywhere from the first week or 2 weeks after that date. So June, July, August are going to be busy times for ESG contracts. Next slide, please. A reminder that the FMR waiver request, we will be submitting one to HUD regarding the FMR restrictions. I know we've talked about this, I think, a couple weeks in a row, but just in case you're getting wind of it, we will support that. Please reach out to us and we will include your request with our request. And any questions, once again, contact your ESG rep or send us an email at the NOFA inbox. Next slide, please.
1 minute before we move on, please.
Oh, yes.
Connie, is there any more that you would like to add to that slide?
No, Anthony no, thank you. No, Anthony said that beautifully. So just
okay.
We do have one jurisdiction that we met with on this week to start discussing this. So as Anthony said, if it's something that you have done or proposing or thinking about in your area, we'd love to visit with you. So reach out. He gave you a lot of different resources and places to reach out to us. You can always write to me also. So thank you.
Thank you, Connie. And next slide, please. And this slide, once again, shows all of the policy documents that are available to you. This is a very helpful resource, especially, as I mentioned, in the upcoming 3 months, June, July, and August, when we're going to be ending contracts, beginning contracts, and trying to spend our money and trying to serve the homeless. So these are great resources for all of you, and they are available on the ESG website. We are constantly updating that. Next slide, please. And finally, here's the contact information for your representatives on the ESG annual team: Diana Prado, Giovanni Martinez, Tuesday Cool, and myself, Anthony Zepeda. Reach out to us. And if you're not sure who your rep is, you can always send an email to the ESG NOFA inbox. And that's also our, as mentioned before, our general question inbox. So thank you very much. And we'll see you next time.
Thank you, Anthony and Connie. And now for our ESG CV updates. Reminder for performance milestones: all program funds for projects, street outreach, emergency shelter, rapid rehousing, homelessness prevention, all must be expended by September 30th, 2023. All funds for HMIS and administrative costs shall be expended by October 31st, 2023. And all final RFFs must be submitted to the department no later than November 15th, 2023. Next slide. And reminders while you're planning your ESG CV closeout: spend down timing. Know when you're approaching the end. Know that most funds are due to be spent by September 30th, so don't spend too fast, but time it just right. Funding continuity, including HCAP funding flexibility. Consider HCAP funding and other funding streams that will allow you to continue to serve clients after closeout. Closing intake. Projected dates for closing client intake for rental assistance. Set dates and deadlines to stop accepting clients or client intake and prepare for final rapid rehousing assistance. Staffing issues. Estimate declining caseloads for staff roles and workloads. Just like we need to make sure we are not leaving participants with nowhere to go, we also need to make sure we are thinking of ways to keep our staff employed. Client issues. Involving and informing participants well before end of assistance. Make sure that you involve and inform participants timely before assistance ends so they can prepare as well. No clients should become homeless because a program is closing. Next slide. Our office hours updates. Upcoming office hours: on May 24th, eligibility documentation for rapid rehousing and homelessness prevention. May 31st, income evaluation for rapid rehousing and homelessness prevention. June 7th, policy smorgasbord. June 14th, COC collaboration requirements. And please remember that you can use the links at the bottom of this slide to register for future office hours and view past trainings. Those links are also dropped into the chat for your convenience. Next slide. Upcoming trainings for June. June 6th, Rent Reasonableness Policy Clinic. This session will review HUD's rules for rent reasonableness, learn about how to show rent reasonableness in California's higher priced housing market, and work together on the documentation required to complete a unit file. June 8th, HMIS Data Quality Program Management, Session 1. This session will focus on the data quality aspects of completeness and accuracy. How much of the required data do you have in HMIS, and how much of this data, how much is the data you have a reflection of any given person's reality? Next slide. June 22nd, HMIS Data Quality Program Management, Session 2. This session will focus on the data quality aspects of timeliness and consistency and talk through the components through the lens of a comprehensive DQMP. Next slide. Do we have any questions at this time? Don't see any in the chat. Next slide, please. If you have any further questions, please contact your annual ESG rep or reach out to ESG NOFA at hcd.ca.gov or reach out to your ESG CV grant administrator. Next slide. And now we'll turn it over to Gordon and Kristen for ESG and VAWA.
All right, good morning, everybody. My name is Gordon Levine. My pronouns are he, him. I am white and Jewish, and I am a technical assistance provider with ICF. We're here to talk today about the Violence Against Women Act, or VAWA, and how it interacts with ESG. I'd like to take a moment to invite my co-presenter, Kristen, to introduce herself.
Good morning, everybody. My name is Kristen Delkamp, and I am an ESG CV grant administrator. Thank you, Gordon.
Thank you, Kristen. For those of you listening at home, introvite is not indeed a word. We will not be using it in the future. Let's dive right in. Next slide, please. All right, so we're putting out here a content warning on what we're going to be talking about today. This presentation focuses on implementation requirements and bracketing that implementation requirements related to the Violence Against Women Act, or again, VAWA. Both the slides and the discussion are going to touch on domestic violence and subjects related to domestic violence, which include but aren't limited to sexual assault, stalking, dating violence, and other forms of intimate partner violence and victimization. I want to reassure you that this presentation slides do not contain explicit imagery or language. However, we're aware that the content doesn't need to be explicit to be triggering. We encourage y'all to take breaks, disengage, or request this information in a different format at a later date as needed, so that this is as accessible and approachable to you as it needs to be. Next slide, please. As always, we're noting that this training focuses on subrecipient and sub-subrecipient implementation. ESG really flows downstream from HUD through a variety of different hands. This is about what y'all do once you receive it from HCD. The front half of the presentation is about what VAWA is. The back half of the presentation is about how it intersects with ESG. And then the back half, which is 3 halves if you're counting at home, will be Q&A related to both subjects. And I do want to note that we have received questions about VAWA in previous trainings that were not about VAWA. We reviewed those, we're prepped to answer them. This is really a good place for you to ask your VAWA questions. Drop them in the chat when you've got them. We'll get to them at the moment if it feels right, or hold it to the end. But don't be shy. This is the right place to ask. Next slide, please. So VAWA and ESG. So the Violence Against Women Act, which was most recently reauthorized at the beginning of 2023, is the Violence Against Women Act of 2022. It needs to be reauthorized every 5 years. It's a big freaking piece of legislation. It's very large. It touches on many different aspects of life. It touches on housing and the Department of Justice, and it's very large. And so the Violence Against Women Act is this really big cross-cutting piece of legislation in much the same way that 2 CFR 200, which is federal cost principles for all federal awards, touch on many different agencies, funding sources, and activities. So VAWA is big. The parts of VAWA that affect ESG are a subsection of VAWA. And that subsection includes both the things that are explicitly about ESG, and there are a couple of things in VAWA that say ESG has to do this. The parts of VAWA that affect housing, which affect many elements of ESG, and the parts of VAWA that affect all people who are survivors of domestic violence, irrespective of what we're talking about. Those VAWA protections, and if you take nothing else away from this slide or this presentation, I beg you to hear this piece. This is like, if I could have put giant red arrows pointing at this thing and it wouldn't have looked just terrible with color scheme and would have done it, hear this. VAWA protections, what we're talking about today, apply to all ESG participants, regardless of what project type they're in, regardless of whether they say whether they register to you up front that they are fleeing domestic violence, regardless whether they register to you at all, regardless of whether they are or are not in a project that has people fleeing domestic violence as a target subpopulation, as a prioritized subpopulation. This is really about how ESG serves all people, not how ESG serves participants in DV specific projects. Next slide, please. So what VAWA does is it creates a framework for defining domestic violence. And I should add that the definition in 2022 is much more explicit and expansive than the definition in the previous edition of VAWA, which itself expanded on the previous edition, and so on and so on. It creates or it establishes rather legal tools to combat domestic violence. So that's sort of beyond the scope of what we're talking about here today. It funds services for victims of domestic violence and domestic violence survivors. Primary funding sources that you might have heard of include the Family Violence Prevention Services Act, or FIPSA, and VOCA, which I can never remember the acronym for, and you'll have to forgive me. Those are the typical sort of DV sources that we think of. Those are funding that come through VAWA. And finally, it funds a variety of other activities, including violence reduction programs, healthcare system response, and culturally specific activities. And again, most of that's way outside the scope of this session, but it's a great piece of legislation. You should go ahead and look it up if you've got a minute. There is a link on the slide, and you can get to it if you just Google VAWA 2022. Next slide, please. So, defining domestic violence is trickier than you might necessarily think. There are several different definitions floating around. The VAWA 2022 and VAWA, the previous editions, all have a sort of canonical cross-cutting, this is the federal definition of domestic violence. Those definitions are expanded on and made more specific by agencies that interact with survivors of domestic violence frequently enough that they need a definition that talks to their specific activities. The Office of Violence Against Women, or OVW, in the Department of Justice, has a definition that has historically been understood to be the canonical definition because VOCA and FIPSA are funding sources that flow through OVW. It's the definition that is usually used when people think of as the federal definition. And so that definition is in front of you right now. This is strongly reflected in VAWA 2022. I'm not going to read the whole thing off to you, but it really does encapsulate basically any pattern of abusive behavior in any relationship that's used by one partner to gain or maintain power or control over another intimate partner. And it spans physical, sexual, emotional, economical, psychological, and technological abuse. So it really does encapsulate basically anything that involves that abusive power dynamic. Next slide, please. HUD has a different definition of domestic violence. And different doesn't mean that it's at odds with OVW's definition, and it doesn't mean that it's at odds with the federal definition in the Violence Against Women Act. HUD's definition is focused really specifically on participant eligibility under the Category 4 definition of definition of homelessness. The purpose of HUD's definition of domestic violence is to identify not whether a person is or is not a survivor, but whether they qualify as actively fleeing domestic violence for the purposes of qualifying for programs like ESG. VAWA's housing safeguards apply to 4 main categories of people. People who are fleeing domestic violence, which includes dating violence, sexual assault, stalking, and also human trafficking, which itself includes both labor trafficking and sex trafficking. Domestic violence, incidentally, that human trafficking piece is understood by rulemaking. I apologize, not by rulemaking, by HUD policy. It's incorporated into the current Category 4 definition. VAWA 2022 makes it explicit that it's part of the VAWA 2022 definition. And HUD has made clear in their preview of their implementation of VAWA 2022 that human trafficking will be folded into the revised HUD definition that you can expect to see sometime in the next 2 years. So DV for HUD purposes includes felony or misdemeanor crimes committed by a current or former spouse or intimate partner of the victim under the family or domestic violence laws of the jurisdiction that receives grant funding. In the case of victim services, DV includes the use or attempted use of physical or sexual abuse or a pattern of any other coercive behavior. It's very broad. Any other coercive behavior committed, enabled, or solicited to gain or maintain power and control over a victim that may or may not constitute criminal behavior. Important note, it's just critical to that you hear this, may or may not constitute criminal behavior. Criminal behavior is not a prerequisite for domestic violence. Committed by a person who is a current or former spouse or intimate partner of the victim, or a person who is similarly situated to a spouse of the victim. So we're talking about, domestic partners, dating partners, etc. Someone who is cohabitating or who has cohabitated with the victim as a spouse or partner, someone who shares a child in common with the victim, irrespective of whether they meet any of the other things that we just talked about, and or commits acts against a young adult or adult victim who is protected from those acts under the family or domestic violence laws of the jurisdiction. Other critical note, domestic violence can happen to anyone, regardless of race, age, sexual orientation, religion, sex, or gender identity, socioeconomic background, education level, people who are in same-sex or opposite-sex relationships. And that asterisk there is because this is language from the White House briefing on this. We recognize that there are relationships that are encapsulated by this definition that are not same-sex or opposite sex. Those aren't the only two options. It's a spectrum. And to intimate partners who are married, living together, dating, or share a child, all of which is to say that DV can happen to anybody. And just because it's called the Violence Against Women Act doesn't mean that it's about just women. It's about everybody. Again, this is from a White House briefing on VAWA 2022. There's a link at the bottom of the page. You can also Google White House briefing VAWA 2022 and it'll be right there. We encourage you to have a read. It's not long, it is very informative. Next slide, please. So we talked about this some, I'm not going to linger too much. OVW and HUD really have contrasting definitions. OVW, and the reason we highlight OVW is it is the common definition used by many places, especially by your victim services providers partners. And they're going to be used to the OVW definition and not the HUD definition. The OVW definition is broader, recognizes a broader range of abuses and victims or survivors, and is not exclusively focused on criminal activity. HUD has a narrower focus. Who qualifies for housing protections? It's got tighter definitions, and there is an extent to which it does have a focus on criminal activities that OVW simply does not for eligibility for certain contracts. Next slide. Over to you, Kristen.
Thank you so much, Gordon, and thank you. It's wonderful co-presenting with Gordon because he knows VAWA inside out and backwards, and we really appreciate the expertise that you bring to the presentation and to all of us. So let's talk about VAWA and ESG. Next slide, please. We're going to start with an overview of VAWA in terms of who are covered housing providers. We'll talk about HMIS comparable databases, prohibitions on eviction and termination on the basis or as a result of domestic violence in housing, and talk about the same subject in the context of shelter. We'll also be talking about notification of occupancy rights under VAWA and the certification form, lease bifurcation, VAWA lease language, and the emergency transfer plan. In all, we're trying to make sure that we give you the tools that you need to implement VAWA on behalf of ESG and ESG CV. Next slide, please. Let's start by talking about covered housing providers, or also known as CHPs. A covered housing provider is an entity that meets any of the following criteria. For the purposes of emergency transfer plan requirements, they administer rental assistance. With respect to the limitations on VAWA assistance under 24 CFR 5.2005D, they are a housing owner. For the purposes of 24 CFR 5.2005D2, which clarifies the circumstances under which a victim of domestic violence may or may not be evicted or have their assistance terminated, they are a housing owner or they administer rental assistance. For the purposes of 24 CFR 5.2007, which defines the procedures for documenting the occurrence of domestic violence, they are a housing owner or they administer rental assistance. Note, HCD and subrecipients may limit requests to document the occurrence of domestic violence in accordance with 24 CFR 576.409B4. Next slide, please. Moving now on to prohibitions on denial of assistance or admission, termination, or removal. We'll look at this in two contexts, one being emergency shelter and one being housing, specifically rapid rehousing or homelessness prevention. With regard to emergency shelter, if an applicant or participant would otherwise qualify for admission or occupancy, applicants cannot be denied admission if they are or have been the victim of domestic violence. In addition, applicants cannot be removed from shelter if they are or have been the victim of domestic violence. For housing, for rapid rehousing or homelessness prevention, if an applicant or participant would otherwise qualify for admission or occupancy, applicants cannot be denied admission if they are or have been the victim of domestic violence. Participants cannot be evicted from their housing solely because they are a victim of domestic violence, and participants cannot have their housing assistance terminated solely because they are a victim of domestic violence. Next slide, please. So let's talk about occupancy rights under VAWA, and this kind of gets to the nuts and bolts of administering paper with our clients. Each entity responsible for administering rental assistance is also required to provide the following two forms to each ESG applicant and each ESG participant. The first is the Notice of Occupancy Rights under VAWA, which is also known as Form HUD 5380. We included in these slides that this one is 8 pages long and the next is 2 pages long, just because there can be questions. And so when you're administering, you know what to look like. The second is certification of domestic violence, dating violence, sexual assault or stalking, and alternative documentation. This is also known as Form HUD 5382. These forms must be provided at each of the following times. First, when an applicant is denied ESG rental assistance. Next, when an applicant's application for a unit receiving PBRA is denied. When a participant begins receiving ESG assistance. When a participant is notified of termination of ESG rental assistance. And when a participant receives notice of eviction. Next slide, please. In terms of lease bifurcation, when a family receiving tenant-based rental assistance separates under the lease bifurcation clause of 24 CFR 5.2009A, their TBRA and their utility assistance, if any, must continue for the family members who are not evicted or removed. When a family living under project-based rental assistance unit separates under the lease bifurcation clause of 24 CFR 5.2009A, the family members who are not evicted or removed can remain in the PBRA unit without interruption to the unit's rental assistance or utility assistance. Next slide, please. In terms of VAWA lease language requirements, subrecipients are required to ensure that the VAWA lease language requirements under 24 CFR Part 5, Subpart L are included in all ESG rental assistance agreements and leases. If a landlord-provided lease includes all relevant protections, subrecipients do not need to take any further action. However, under most circumstances, subrecipients must attach a lease addendum, including the necessary language. Subrecipients have 3 sublease options. First, they could choose HUD sample lease addendum, which is HUD Form 91067. Second, they can choose California HCD's VAWA lease addendum, which is based on Form HUD 91067. Or third, a subrecipient developed lease addendum based on Form HUD 91067. So that's the create your own version. Subrecipients should define their approaches to VAWA lease language in their written standards and/or project policies and procedures. Next slide, please. Let's talk about emergency transfer plan required elements. Subrecipients that administer rental assistance must develop and implement an ETP. The purpose of the ETP is to enable participants who are victims of domestic violence to transfer from an existing unit to another safe unit without an interruption in their ESG assistance. ETP takes effect when a qualifying participant requests it, and either the participant reasonably believes there is a threat of imminent harm from further violence if they remain within their current housing, or if the participant is a victim of sexual assault. In the case of a victim being a victim of a sexual assault, we also need to look at, do they meet the above criterion, meaning do they reasonably believe there is a threat of imminent harm from further violence, or the sexual assault occurred on the premises of their unit within the 90-day calendar day period preceding the date of the ETP request. For families receiving TBRA, you must specify what will happen regarding the non-transferring family members. For families receiving housing that is not TBRA, for ETP qualifying participants, if a safe unit is not immediately available, the ETP qualifying participant has priority over all other applicants for ESG housing. Certain conditions do apply, and you can see 24 CFR 578.99 J8 for those details. Next slide, please. ETP required elements must incorporate prioritization information in relation to other housing applicants. As a best practice, integrate this with your coordinated entry. It must have strict confidentiality provisions. It must allow the participant to make an internal transfer when a safe unit is immediately available. It must have provisions for internal transfers if a safe unit is not immediately available. And it must describe reasonable efforts that the CHP will take when a safe unit is not immediately available, including for external transfers. More details on that in 24 CFR 5.2005 E7, as well as in any Q&A that may be coming up at the end of the presentation. Next slide, please. Sticking with ETP required elements, they may require participant documentation, provided that all of the following is true. The participant's written request to the CHP is sufficient to trigger the ETP. The CHP may ask participants to document the occurrence of DV in accordance with 24 CFR 5.2007 if the participant has not already provided documentation, or no other documentation is required to qualify under the ETP. The ETP must be made available upon request and, when feasible, publicly available. CHPs must keep records of all ETP requests and the outcomes of those requests. Next slide, please. In terms of VAWA and client file checklists, for emergency shelter, nothing is needed in the file, but victims are required to be served at any available shelter, whether or not it's a DV shelter. For homelessness prevention and rapid rehousing, we want to see in the file the VAWA lease agreement. That must be an addendum to the residential lease agreement. The VAWA notice of occupancy rights, which is Form HUD 5380, provided at the required times outlined in 24 CFR 576.409C. See slide 13 for timing. We've already discussed this. The VAWA victim certification form, if applicable, and the VAWA emergency transfer request, if applicable. And now, next slide, please. We move into the third half, as Gordon said earlier, of our presentation, which is likely the most important piece, where we are going to answer your questions. So looking into the chat here, and Gordon, while looking into the chat, is there anything that you'd like to add based on the slides that I just presented?
Yeah, I think I would just add that Complying, there really are only two big requirements under VAWA for ESG, which is having an emergency transfer plan, following it, and implementing the lease amendment. But they are large pieces, and I don't have a count of how many people there are currently in the audience, but every one of you is probably freaking out right now because you do not have a compliant emergency transfer plan and you do not have lease amendments attached to any or all of your leases. I want to reassure you that that is common, right? That's a normal thing, not a good thing, and it's not what HUD wants to see, but it is not universally true, but it's very common that most ESG subrecipients at this point have not come fully into compliance with Violence Against Women Act's requirements, even though they have been active since around 2018. Same thing is true for COC program recipients. All of which is to say that you have an opportunity here to get ahead of the curve, identify what the requirements are, and begin putting them into place rather than continue not addressing these requirements as HUD continues to identify them as a priority. So really, I would take the fact that you're not currently fully compliant, not as a like, oh God, we're in trouble moment, but as a like, oh, there's an opportunity to move forward moment. Yeah, that's what I would add.
Okay, well, thank you. Let's jump to our questions. We've got several. So first off, what is the best way to demonstrate in a client file that you provided these forms at specific times? Can you just type it in the case notes, or do you have to have copies of the forms in the file each time you provide it? Trying to think about saving paper.
Sure. So I'll go ahead and take that one.
Okay.
So it's tricky, right? I think everybody who read that slide, I certainly felt this way the first time I had a look at this requirement in VAWA, that there was a lot of times you had to provide those stinking forms. And surely by the fourth time, the participant must have their arms completely around this. And the fifth time must be unnecessary, right? And so I'm going to answer this question in two parts. One of them is what I said in the chat, which is the reason that VAWA, I believe the reason that VAWA requires these forms to be provided so many different times and at those specific times is each of those times represents an inflection point where a participant is likely, if they are covered under VAWA's protections, to want to activate those protections. And so you're required to proactively ensure that participants are informed about their rights and have the tools to take advantage of them at the points when they are most likely to want to do so, if it applies to them. So it seems like a lot, but there's method to that particular challenge. But there is a paperwork concern, right? So that's 10 pages, 5 times per participant-ish, spread over, I don't know, 50 households in a year is, you know, how many trees are you killing for this particular thing? There is not a specific documentation standard in the Violence Against Women Act or in ESG that says this is how you have to document this. And so there's a few different approaches you can take. One of them is you can, and I think like the most, so the most papery way, right, is to print out copies of these, have the participants sign on the copy that they received it, make a copy of the signed copy and stick a copy in the file every single time. The plus side is that that's very hard to argue with. The downside is that that's incredibly staff intensive and paper intensive. It will make your files gigantic. It will take up tons of room in your filing cabinet. It's burdensome. The sort of lighter version of that and the compromise version of it that I like best personally, that I'm recommending just because I think it's a good balance of interests, not because it's the best way or the only way to do it, is the same thing that you would do with like your lead-based paint disclosures or your like house rules document or your project rules document. Have a one pager in the client file checklist that says participant received this document at this time, and just have the participant sign on the line that says, yeah, I received this. And so then you've got your VAWA page, your one VAWA page in the participant file checklist. And every time you hand out those documents, you have the participant sign right down. And at the end of it, you've got signatures and dates from the participant asserting that they received the appropriate documents at the appropriate time. And you can have the documents in question printed out once right behind it, so you're clear about which version of the document you put out. You can also record in HMIS. You can have a service transaction that said participant received XYZ. You can have it in the client's case notes, and the case manager can just note down in there participant received X and not require a signature. Anything in the spectrum between signed in triplicate to case manager attested could theoretically meet the standard. The standard is ultimately going to be set by written policy. HCD's written policies and procedures around VAWA, which do not set the standard. Your subrecipient's written standards, which may or may not set a standard for projects, and your project policies and procedures that says this is how we're going to track this thing. And so ultimately you want to make sure that you've got it in writing in your project policies and procedures that this is how we're going to do this thing. And once you're there, and as long as you're acting in compliance with your own project policies and procedures, which comply with everything else upstream, you're good to go from a compliance angle. It's a great question, and one that I think VAWA really raises but does not directly address.
Thank you, Gordon. And I will say that it is something that we are looking at as we are monitoring communities, that there is some sort of documentation so that we can see that the forms have been distributed as necessary to the clients. So thank you for that. Deidre had asked, will you show these forms so that we can walk through them? I'm not sure that we're prepared to do that today. Gordon, what are your thoughts on that? I know we can certainly send them with the presentation afterwards, but what are your thoughts, Gordon?
Yeah, I think that is not a particularly good use of time, not because it's not important for you to look at the forms, but because the forms themselves are really just, they captured what we've talked about today in a way that is intended to be approachable and comprehensive for participants. They are linked in the slides themselves. They're linked in the chat right now. You can find them by Googling HUD form blah, blah, or the name of the thing. And everything in there should be what we've already talked about. So I wouldn't worry about us going through today.
Thank you, Gordon. And we have a question from Cassie. Do the VAWA notification forms need to be provided again once the client is self-sufficient in paying their rent in full, so the funding ends but is not necessarily terminated for ineligibility?
This is an interesting question. Kristen, do you have a thought? I'm happy to field it if this is in the deep end of the pool, but do you have a thought?
My thought is that we are sticking to those specific period points that have already been laid out on slide 13, which you can go back and reference when you get this presentation. So I think that it is not necessary to be doing that at the time that Cassie mentioned. What do you think, Gordon?
Yeah, I think you're right on. The VAWA notification forms do not need to be provided when you discontinue rental assistance if the participant is still enrolled in the project, but they do need to be provided when the participant is terminated, regardless of whether that happens with subsidy discontinuation. So yeah, spot on.
Okay.
Great job, Kristen. Thank you too, Gordon. Also from Deidre, ETP policies are only required for DV agencies?
No.
I will. So good news and bad news, mostly bad news. From a operational requirement standpoint. Remember the thing I said at the beginning of the presentation, where this presentation is about how we serve all people in ESG and how it's about all ESG projects, not just about VSPs and DV specific projects. This is the question I was trying to preempt. It's a good question and a really acute one. And I want to make sure that we take advantage of the opportunity to say really clearly that these lease addenda and emergency transfer policies are required to be implemented by every ESG project, regardless of whether they think they're serving people who are fleeing DV or not. By the way, you are, even if you don't know it. Regardless of whether the agency is a victim services provider or not, it's everybody. Couple of reasons for that, and then I'll talk about why. The most important one is many people who are impacted by domestic violence don't want to tell you and don't have to tell you, or don't want to tell you until they need the protections that VAWA offers. And so the person who walks through the door and is like, yep, I am experiencing literal homelessness and also category 4 homelessness. I would like my certification, please. That's an unusual participant. It's much more common that participants will gradually disclose the things that are challenging to disclose. In much the same way that there are many questions on, for example, the VI SPDAT, that participants, if you use it as a handshake, are not going to want to answer because they're really intrusive, right? They're vulnerable questions that a participant who's known you for 6 months might answer honestly, but day one, they're not going to give you an answer. They're not even going to lie to you. They're just going to say no, right? They will refuse to answer this question. The reality is that domestic violence is much more common than we would like to admit, and all projects all of our ESG projects are serving people who are fleeing domestic violence or survivors of domestic violence, whether a participant chooses to own that to a case manager or not at any given time. So in terms of what's actually required, HUD requires that state ESG recipients, so HCD, have an emergency transfer policy that applies to the entire state's ESG, or it can choose to not have one and pass that responsibility down to its direct subrecipients, which it does. So HCD does not have a one-size-fits-all emergency transfer plan. It instead requires that each subrecipient develop an emergency transfer plan. Subrecipients have to develop an emergency transfer plan, and that can have there is a model emergency transfer plan. I think we link that upstream in this presentation. You can also just Google HUD VAWA emergency transfer plan model, and it's right there. It's 100 years old at this point, and it's really intended to just hit the bare bones of what you have to do. But they can be more complicated. They can be more specific. They can push some of their responsibilities down onto their providers, which might be the subrecipient or their subs. There's a lot of different ways it can be implemented, but the key point is everybody's got to have an emergency transfer plan at the subrecipient level, and it affects all projects, regardless of whether they say or think they are DV specific. Kristen, anything you want to add?
Nope, I think you covered it.
This incidentally is the part where everyone in the audience who is not already freaking out is now freaking out. And what I will just highlight to you is that emergency transfer plans, most subrecipients and recipients don't have them yet. Or if they do, you might not know about it because they adopted the model plan in 2018 and they've never looked back at it. It's easier than you think. It does require you to pay a little bit of attention. It is infrequently activated, but you'll be glad it's there when it's there and when you need it.
Thank you both. Next question. Is the expectation to get addendums to leases with current participants or just new participants moving forward?
This is
Yes.
a really good question. Kristen, you're on it. Have it.
Yes is the answer to that question. So the expectation is certainly for new participants moving forward to be administering the necessary forms and providing those handouts. And in terms of current participants, yes, we would like those to come current with that information. So to me, that is a yes and yes type of a question. Gordon, anything that you'd like to add on that?
Yeah, I think I want to complicate that a little bit. Not to say that I don't
Okay.
So I think I fundamentally agree that that right now we want, if I had a magic wand, all of our leases would be compliant, right? That's the ideal. I think there's a balance of interests thing here. If you have leases that do not currently have VAWA lease addendums, you are out of a VAWA lease addendum or the VAWA lease language in it, you are out of compliance with VAWA. But that, unfortunately, that's very common. And so there's nested interests here. One of them is compliance, and HUD cares that you come into compliance. From a HUD monitoring perspective, which is always the perspective that we're kind of bringing to this, HUD's not going to ding you up if HUD is unlikely to ding you up. If, you know, suddenly your field officer HUD National were to drop in tomorrow and discover, like, oh, shock of shocks, you don't have all of your lease addenda in place, but you're in the process of making that transition. And as leases turn over, you're attaching new addendums. That's coming into compliance, and that's good. And it's not just about current participants, or not just about new participants, it's about current participants too. If you're renewing your lease, if you're changing your lease, that's when you slide that in and you say, look, this is when we make that change. But also, you know, I think if you go back to landlords in the middle of the lease and say, hey, we goofed, we really need to attach this addendum, that gives participants a way to just exit their lease and you have no recourse about that. You know, I think 9 out of 10 landlords are going to have a problem with that. And you don't want to destroy your relationship with all of your landlords, insisting on modifying existing lease agreements in a way that does not in any way provide for landlord security. And so I think it's fine to say to your landlords, hey, we goofed, we would like to amend this to attach it, and to open that conversation. I also think it's fine if the landlord is like, I'm not doing this, take me to court if you want, to be like, fair enough, we would rather this person remain housed. It gets you into a sticky situation if the participant needs to activate VAWA, but also ESG funds can be used to cover the cost of activating an emergency transfer plan, including covering the cost of breaking a lease. And so at the end of the day, if you need to get a participant out of a lease that doesn't have a lease addendum, you can use ESG to do that, and it doesn't count toward your 24-month cap or any of the rest of it. You can just use the money to do it. So I think there's a balance of interests. I think you should push on it. I don't think you should push on it so hard that it blows up your relationship with your landlords. And I think a really appropriate methodology to adopt that puts you in a good place in terms of coming into compliance is all leases going forward, and as leases turn over, that's the point at which you want to update it. So that's my take. It's a little different. I don't think there is a right way or a wrong way, as long as you are catching new leases now that you know what the rule is. Generally, HUD's approach to compliance is once you know that you should be doing better, as long as you start doing better, it's okay. How far you want to push it, you know, that I think that's up to your own policies and procedures and discussions with your grant administrator and all the rest. No simple answers involved.
Not simple, but I think you covered everything though, so that's good. Had a question from Patricia asking about the slides. The slides and those links for the documents will be sent out in an email after this presentation. Another question. Oh no, I'm sorry. It wasn't a question. Deidre was saying that your answers were very helpful.
Oh, thank you. Deidre had a question upstream about how to talk landlords into being cool with the addendum. And I have some thoughts on that, but I think this is art rather than science. And I would love to hear Kristen's art on this one.
Why don't you start with your science and then I'll back in my art.
Oh, sure. I have no science.
Oh.
But I'll lay some foundational stuff. You know, the bottom line is you got to do it. And that's the science of it. Like you have to, and so the more of a deal you make of it, the more of a deal it is. So if you go to your landlords and you're like, okay, we've been doing this for a few years, but we've got this new amendment, and we were supposed to be doing this for a long time, and we goofed, but now we're coming into compliance, and it's like 5 pages, and it's dense, and it gives your participants a chance to like opt out of your lease, and you don't really have any recourse about it. And we're sorry about that, but we have to do it. If you frame it like that, your landlords are going to freak out. If you frame it like, here is your lease, we put some addendums on it, they're required by federal law, most landlords are going to be like, all right. For landlords who really dig into it and are like, I don't like this amendment, can we not do this amendment? You can give them kind of 2 points of reassurance that I've found helpful. One of them is that it's rarely activated. It's very unusual. First, it doesn't happen very much. And you can tell them like, I've been in this business for however many years, and I've seen like 0 of these ever actually happen. So this is not normal, right? This is not normative, first. Second, it's our goal to ensure that you're compensated to some extent to gap that over. And so if we need to bounce in a hurry, we're within our power to say like, yeah, we'll cover this until you find another participant to some extent, if that's in your policies and procedures. And so having that kind of safety net, you write that in and that's fine. And third, if a landlord is like, oh, but what if you like leave me with this bag and I can't re-up this apartment? You're like, look, we're in a housing shortage. Even if this unit isn't safe for this participant due to something in their life, do you really think we don't want to keep this unit? If this participant moves out and like we can establish that this unit is safe for a new participant, which it is most of the time, DV is not like location specific in this way. Yeah, we'll keep it empty and hold it for 30 days and then move somebody in after them. We want this unit. That's why we're signing a lease. We like this unit. And so reassuring landlords that your goal is to keep this unit under lease for your participants, regardless of who happens to be in there, can go a long way to reassuring. Kristen, what art do you have?
I think that you created the mosaic, you created the tapestry that I was moving towards, which is a balance of, there is a federal law that makes this a requirement, but then also blending it with there is a housing shortage, and we don't want to do anything to jeopardize the unit. We need to administer as per the law, but we certainly value you as a partner in our fight for affordable housing and end homelessness. And so, yeah, I think you hit on all the points that I thought were salient as well.
Well, I'm sorry to take the words out of your mouth, but yep, I think we're on the same page. LaQuantia, were there any other questions? I think that was everything.
Yep, I don't see any more on our end, unless someone wanted to come off mute really, really quick and ask a question. I think that's all that we have.
All right, well, I'm good to go. From me and Kristen, thanks for your time and thanks for your really good questions. As always, it's a pleasure spending this time with you. We hope you learned a lot. And if you have any follow-ups, please do let your grant administrators know. We know that this is new for many of you, and we wish you luck and success in navigating VAWA and ESG.
And thank you, Kristen and Gordon, for a wonderful presentation and answers to all of our questions. If you do have more questions, feel free to shoot us an email, to ask, and we'll get those answers back to you. Remember that as you exit this session, that a survey will launch. If you would please answer that for us so that we can cater to your specific needs on the trainings and spotlight sessions that we have. Thank you, everyone. Have a good week. We'll see you next week.